Breaking news, a Trump-appointed federal judge in Texas ruled that the president unlawfully invoked the Alien Enemies Act and blocked the administration from quickly deporting some alleged gang members. I want to quickly bring in Priscilla Alvarez, who's got the details. Priscilla, tell us more.
Dana, this is a significant blow for the Trump administration, which has wanted to lean on this sweeping wartime authority, the Alien Enemies Act. Well, a federal judge in Texas saying just moments ago that the president exceeded his authority by invoking this law that was intended to be used during wartime. Let me read you a snippet of what he said. He said, quote, allowing the president to unilaterally define the conditions when he may invoke the AEA, the Alien Enemies Act, and then summarily declare that those conditions exist would remove all limitations to the executive branch's authority under the AEA and would strip the courts of their traditional role of interpreting congressional statutes to determine whether a government official has exceeded the statute's scope.
All right, folks. Welcome to Dr. John Podcast right now. A federal courtroom just witnessed a moment that historians may mark as reality colliding with Trump's narrative of judicial transformation. Despite years of claiming his judicial appointments would secure his legacy, institutional power just proved that the courts ultimately answer to the law, not to the president who appointed them. And now here we are, one of those very judges, a judge Trump himself selected, a judge whose confirmation Trump supporters celebrated with champagne toasts and triumphant social media posts. A judge who was supposed to be different from the so-called activist judges Trump complained about with such theatrical fury. That judge has just handed down what legal analysts across the ideological spectrum are calling the most damaging judicial ruling yet against Trump's second-term agenda. But here is where it gets even more interesting, because that judge is not alone. Trump's own appointees have been ruling against him in case after case.
Goes on to say the law does not support this position. The position, Dana, that the administration has taken is that Tren de Aragua, that Venezuelan gang, is a foreign terrorist organization and that they are invading the United States. And so the administration has said that they can use the authority based on that. Well, this federal judge is not buying it, according to this opinion. And Dana, while there have been legal challenges across the country over the use of this act, this is again the first time that a federal judge is weighing in on whether or not the president exceeded his authority. ACLU's Lee Gallant told me in a statement that this is the first court, quote, to squarely rule on the fundamental question of whether a wartime authority can be used during peacetime, and properly concluded it cannot. Now, as far as for the immigrants who are detained in this judge's district, they cannot be deported under this authority as of now. But again, that is constrained to those in his district. But of course, Dana, this is going to launch perhaps several more steps in the court system
across the most contested and consequential areas of his policy push. Immigration enforcement, emergency powers, media access, the very domains where Trump's legal team put forward their most aggressive and sweeping claims about presidential authority. And in those domains, his own judges have been looking at the arguments and delivering a verdict that must be incredibly frustrating for someone who bet so heavily on reshaping the courts. The man who made judicial appointments the centerpiece of his political legacy is watching those courts, the ones he reshaped, push back against the most ambitious exercises of the power he claims to possess. The irony is so thick you could cut it with a gavel. Let me make sure you understand why this matters before we go any deeper. These rulings from Trump-appointed judges are not random occurrences that happen to be clustering together into an inconvenient pattern.
When again, this federal judge says that Trump exceeded his authority to invoke the Alien Enemies Act.
Before I let you go, Priscilla, just on that note, is it just these particular people who are alleged to be part of a gang that can't be deported or sent to that notorious prison in El Salvador, or is this potentially more broad?
That's correct. It is those individuals, Venezuelan migrants, who have been alleged to be part of this gang, who are in this district, who cannot be deported under this authority. There are various other legal challenges playing out around the country as to others who may be eligible based off the administration's determination, but that is who it affects as of this afternoon.
Okay. Thank you so much, Priscilla. I appreciate that. Just to emphasize a couple of things. First of all, that it is a first. It's the first time we have seen a federal judge say that on its merit, the Alien Enemies Act should not be used in this case. but it's also the who of it all. Judge Fernando Rodriguez of the Southern District of Texas was appointed by Donald Trump.
He was back in 2017, the president's first year in office. And this is something that
They reflect something specific and deeply important about the relationship between conservative judicial philosophy and executive power, something that Trump's legal team apparently did not fully consider when they were designing their second-term strategy. You see, Trump's judicial appointments were made with extraordinary care and attention to conservative legal principles. The selection process, working hand in hand with organizations that had spent decades cultivating a pipeline of intellectually rigorous conservative lawyers, focused on nominees who believed in textualism and originalism. These are the principles that courts should interpret laws as they are actually written, not expand them to accommodate executive preferences or political goals. Those are the principles the Federalist Society and the entire judicial selection apparatus prioritized.
we really shouldn't have to say because a federal judge rules as they rule, but it has become part of the fight in all of this, if it's an Obama-appointed judge or whatnot. So it was a Trump-appointed judge. And the reason it's significant for what Priscilla was laying out there is because it's more difficult for the White House to sort of go after this judge, as he has been doing on Judge Boasberg here in Washington and others. But I think a bigger question is this, likely to end up in the Supreme Court or something, and does the White House follow this? As of now, the president, has says that he does follow the rulings and orders of judges. So we shall see. But 1798, that's when the Alien Enemies Act was signed, only used 3 times in wartime. So the minute that was signed and happened, which was on a Saturday, you knew that it would be challenged, and this is it.
Yeah, they are not surprised by any of this. This is certainly the biggest blow, but this is the biggest blow in a series of setbacks in the courts for the Trump administration. But what I'm hearing inside is that there's the legal piece of it, right? And they will fight this in the courts. But for Trump in particular, just as important is the messaging and communications fight on this. It's going to be tougher because this is a Trump-appointed judge, but they are saying, and you heard Stephen Miller, I was in the briefing room, you were there today, say that.
And those are exactly the principles that are producing the rulings that are going against him. Because textualism and originalism do not automatically generate outcomes that favor executive power. They generate outcomes that favor what the text actually says and what the original meaning of constitutional provisions actually was. When the Trump administration's legal theories require courts to stretch statutes beyond their plain meaning or to read constitutional provisions as conferring authority that the text and history do not actually support, Trump's own textualist and originalist judges are the ones most likely to say no. This is where we need to bring in the historical context that gives this moment its full weight. Trump's judicial appointment strategy was one of the most systematic and deliberate in American history. Working with the Federalist Society and with Senate Republicans who prioritized judicial confirmations above almost everything else during his first term, Trump placed over 230 federal judges on the bench, 3 Supreme Court justices, 54 Circuit Court judges, more than 170 district court judges. The pace and scale of those appointments were unprecedented in recent history and were the result of a conscious and sustained effort to reshape the federal judiciary in ways that would outlast any single administration. The people doing the selecting were not choosing randomly or based primarily on personal loyalty. They were applying rigorous intellectual criteria. They were looking for nominees with documented commitment to conservative legal principles. They were seeking out individuals with strong track records in legal academia or practice with clear and consistent judicial philosophies. And now, the irony of where that process has led is not lost on anyone paying attention. The very rigor of the selection process, the emphasis on intellectual consistency and principled legal methodology rather than personal loyalty, is what is producing judges who are willing to rule against the administration that nominated them when the administration's legal theories are not consistent with the legal principles those judges were selected to apply. A selection process optimized for intellectual rigor rather than than political loyalty, produced judges who are applying intellectual rigor rather than political loyalty. That is the system working exactly as it was designed to work, even if it is producing results that nobody on Trump's political team anticipated or wanted. So stay with me here, because we are about to go deep on exactly what these rulings found and why they are as damaging as they are. We are going to look at the specific legal findings, the most significant cases, and the broader pattern those findings reflect when you consider them together. Let us start with the Alien Enemies Act case, because it is the most significant and most revealing of the rulings that have come from Trump's own appointees. This law dates all the way back to 1798, making it one of the oldest statutes still on the books. It gives the president authority to detain and remove nationals of a hostile foreign nation during times of war or declared national emergency involving an invasion or predatory incursion by that nation. Now, the Trump administration's legal theory was that it could invoke this ancient statute to detain and deport Venezuelan migrants by characterizing the presence of members of the Venezuelan gang Tren de Aragua in the United States as an invasion or predatory incursion by Venezuela. Think about what that argument required. The administration was essentially claiming that gang-related criminal activity by some Venezuelan nationals constituted an invasion of the United States by Venezuela, sufficient to trigger a wartime emergency deportation statute from the 18th century. That characterization was an extraordinarily aggressive stretch of both the statute's plain text and its historical meaning. And the Trump-appointed judge in Texas who examined that theory looked at the Alien Enemies Act, looked at its history and its plain meaning, and said something very direct. Describing gang-related criminal activity as an invasion or predatory incursion did not meet the historical understanding required to trigger the statute. The president lacked lawful authority to detain or expel the migrants under that provision. The legal theory was wrong. The judge, applying the textualist and originalist methodology that Trump's judicial selection process was specifically designed to produce, reached that conclusion. Trump's own judges are applying the judicial philosophy Trump's own selection process prioritized and getting answers Trump's legal team did not want. That is not judicial activism. That is textualism working exactly the way it is supposed to work. Now let us talk about the ICE detention ruling, because it adds another dimension to this story that is even more damaging in some ways. A Trump-appointed federal judge issued what analysts described as a scathing order against immigration and customs enforcement over a mass detention operation. The ruling concluded that ICE authorities violated detainees' constitutional rights through overcrowding facilities and effectively cutting off access to legal counsel. The order was not just legally significant. The language the judge used was pointed and sharp in ways that judicial opinions rarely are. The judge ordered ICE to immediately restore meaningful attorney access, including unmonitored phone calls and expanded visiting hours. And here is where it gets really interesting. The judge specifically criticized the government for suggesting that honoring constitutional rights would lead to chaos. Think about what that means. The government's lawyers had apparently argued to the court that if detainees were given constitutionally required access to attorneys, the result would be chaos in the detention system. And the Trump-appointed judge looked at that argument and responded with language that made clear exactly how the court evaluated an argument that constitutional compliance would produce chaos. That level of judicial criticism, that specific and pointed a rebuke of the government's legal position from a judge who sits on the bench because Trump nominated him, sends a signal that reverberates far beyond the specific detention operation at issue in the case. It signals that the Trump administration's approach to executive power and immigration enforcement is not only legally vulnerable, but that its legal arguments are sometimes so poorly grounded in constitutional reality that judges who share the administration's general judicial philosophy are reacting with overt frustration and sharp criticism. A judge that Trump put on the bench is publicly criticizing the government's suggestion that following the Constitution would cause chaos. That is a judicial rebuke that cuts through every political framing the administration might try to put around the decision. Let us step back and look at the broader pattern, because these cases are not isolated incidents. They are part of what analysts across the legal and and political spectrum are describing as a documented and consistent pattern of Trump-appointed judges pushing back against the most expansive claims of executive authority that Trump's second-term legal team have been advancing. Multiple Trump-appointed judges have blocked administration efforts in areas including immigration crackdowns, the use of the National Guard for domestic law enforcement purposes, and various emergency power claims. In each of these cases, the pattern is the same. The administration puts forward a broad and aggressive claim of executive authority grounded in an expansive reading of a statutory provision or constitutional power. The Trump-appointed judge looks at the statute or the constitutional provision the administration is relying on, applies the textualist or originalist methodology that Trump's judicial selection process was designed to produce, and finds that the statute does not say what the administration needs it to say, or that the constitutional provision does not confer the authority the administration is claiming. Legal scholars tracking this pattern point to the life tenure feature of federal judgeships as a key institutional explanation for what is happening. Federal judges, once confirmed, have no ongoing political relationship with the president who nominated them. They are not accountable to that president for their decisions. They do not face re-election or reappointment. The independence that life tenure provides is precisely the independence the Constitution's framers intended federal judges to have. The independence to apply the law as written rather than as any political actor, including the president who nominated them, would prefer. And I want to add one more dimension to the Alien Enemies Act ruling specifically, because it is the clearest and most documented example of what happens when executive overreach meets a judge who was selected specifically for their commitment to reading statutes as they are actually written. The Alien Enemies Act of 1798 was designed for a specific and historically grounded purpose. It was created during a period when the United States was in a quasi-war with France, and when Congress believed the president needed a specific statutory tool to address the presence of nationals of hostile foreign powers on American soil during times of declared war or declared invasion. That was the threat it was designed to respond to, not gang activity, not transnational criminal organizations, not the presence in the United States of nationals of a country whose government is hostile, but who have committed no act of war against the United States as a nation. The historical understanding of what invasion and predatory incursion meant in 1798, the understanding that a textualist or originalist methodology requires a court to apply, is dramatically narrower than what the Trump administration was arguing the statute covered. The Trump-appointed judge looked at that original understanding, looked at the administration's theory, and found that the gap between the two was too wide to bridge through any reasonable interpretive methodology. That is not a judge going rogue. That is a judge doing exactly what conservative judicial philosophy prescribes. Now let us talk about Trump's reaction to the rulings from his own appointees, because it is revealing in a very specific and important way. Throughout both of his terms, Trump has publicly attacked judges and courts that rule against him. He has questioned the legitimacy of rulings he disagrees with. He has called judges biased and accused them of being political actors dressed in robes. But when the judges ruling against him are judges he himself put on the bench, when the people delivering the rulings that undercut his agenda are people whose careers he was directly responsible for elevating to the federal bench, the standard attack lines become much harder to deploy credibly. You cannot simultaneously take credit for the judges you nominated and dismiss the independence they are demonstrating as evidence of bias. You cannot brag about reshaping the judiciary and then characterize the judiciary's rulings as illegitimate because you do not like the outcomes. The rulings from Trump appointed judges trap Trump's political messaging in a contradiction that is very difficult to escape. In that contradiction, the gap between the story he tells about judicial appointments and the reality of what those appointed judges are actually doing is one of the most politically damaging aspects of the pattern that is now clearly emerging. The judicial legacy he pointed to as his most durable achievement is producing rulings he is losing it over, and there is nobody else to blame for who is sitting on those benches. Here is something important that many observers are missing. The rulings from Trump-appointed judges are more legally powerful as precedents than rulings from judges appointed by Democratic presidents would be in exactly the same cases. Here is why that matters beyond the immediate outcome of any specific case. When a Democratic-appointed judge rules against a Republican administration's immigration enforcement theory or its emergency power claims, the ruling can be and routinely is dismissed by the administration's supporters as the predictable output of a politically biased judge who was always going to rule against Republican policies regardless of the legal merits. That dismissal is sometimes unfair and sometimes accurate, but it is always politically available and always politically effective, with a base that wants to believe the courts are stacked against them. When a Trump-appointed judge rules against the same theory or the same claim, the political dismissal is not available. You cannot call a Trump-appointed judge politically biased against Trump. You cannot argue that a Federalist Society vetted textualist and originalist is predisposed to rule against conservative policy arguments. The ruling has to be engaged with on its merits or not engaged with at all. And rulings that have to be engaged with on their merits are rulings that carry more weight in subsequent cases, that are more likely to be cited by other courts, more likely to be relied on by future plaintiffs challenging similar executive actions, and more likely to constrain future exercises of the same expansive authority claims that produced the original ruling. A ruling from a Trump appointee that says the Alien Enemies Act does not authorize what the Trump administration did is worth more as a legal precedent than the same ruling from an Obama or Biden appointee would be. The source matters as much as the substance in determining how durable and how influential a judicial ruling becomes. The pattern of Trump-appointed judges ruling against his second-term agenda reveals something important about the relationship between judicial philosophy and executive overreach that everyone following this story needs to understand clearly. Here is the thing about conservative judicial philosophy that Trump's legal team apparently underestimated. Textualism and originalism are not tools for maximizing executive power. They are tools for constraining all power, including and especially executive power, to what the text of the Constitution and the statutes actually authorize. The founders who wrote the Constitution were deeply suspicious of concentrated executive power. The original understanding of the Constitution's structural provisions, the separation of powers, the enumeration of specific executive authorities, the checks and balances that run throughout the document, all of it reflects a deliberate design to limit what any single actor in the government can do unilaterally. When Trump's legal team advances legal theories that require courts to read executive authority as dramatically broader than the text of the relevant statutes or the original understanding of the constitutional provisions at issue, they are asking textualist and originalist judges to do something that is in fundamental tension with the judicial philosophy those judges were selected to apply. And the judges are declining to do it, not because they are politically opposed to Trump's policy goals, but because the legal theories are not defensible under the interpretive framework they are professionally committed to applying. The rulings from Trump-appointed judges are establishing precedents that are going to constrain future administrations of both parties, and that will shape the legal landscape for executive power claims for years and possibly decades. The Alien Enemies Act ruling defines limits on how that statute can be used in ways that every future president will have to operate within. The ICE detention ruling establishes constitutional requirements for how immigration detention facilities must be operated that no future administration can simply ignore. The National Guard and emergency power rulings create legal constraints on how presidents can invoke those authorities that will apply to every future president regardless of party. All of those precedents are being built by judges who were selected for their intellectual rigor and their commitment to the law as written. And the fact that those precedents are emerging from cases involving a Republican administration being challenged by its own Republican-nominated judges makes them more durable, more likely to be treated by other courts, courts as genuinely law-based rather than politically motivated than they would be if they were coming from judges appointed by Democratic presidents. Now, I want to address something that Trump supporters are going to say about this pattern of rulings. They are going to argue that the judges ruling against Trump were either misled during the confirmation process, that they have been intimidated into ruling against him by the institutional pressure that comes with high-profile cases, or that they have simply proven themselves to be less reliably conservative than the selection process suggested they would be. All of those arguments avoid the simplest and most accurate explanation for what is happening. The judges are doing their jobs. They were selected for their intellectual commitment to a rigorous and principled approach to statutory and constitutional interpretation. When they look at the Trump administration's legal theories and find them wanting under that rigorous and principled approach, they rule accordingly. The fact that those rulings go against the administration that nominated them is not evidence that the judges have abandoned their principles. It is evidence that the administration's legal theories are not defensible under those principles. That is a crucial distinction. Judges who rule against the president who nominated them when the law requires it are demonstrating the independence that is the entire point of life tenure federal judgeships. They are proving that the selection process produced judges of genuine intellectual integrity rather than political pawns who could be relied on to deliver whatever outcome the nominating president wanted. That is what judicial independence looks like. And it is exactly what the founders who created life tenure federal judgeships were trying to ensure would exist in the American legal system. The federal judiciary is the one institution specifically designed to be immune to the political pressures that shape every other institution. Presidents come and go, congressional majorities shift, but federal judges, once confirmed, are there for life. Trump appointed his judges, suggesting to his supporters that the appointments were a form of political legacy. What is actually happening is different and more important. The judges he put on the bench are being judges, independent, principled judges who apply the law as written regardless of who would prefer a different result. That is not a betrayal. That is exactly what the selection process said it was optimizing for. The rulings may not be what Trump wanted, but they are exactly what good judging looks like. Stay tuned, because next time we are going deep on the specific second-term policy areas where more rulings from Trump-appointed judges are expected, and what legal analysts say about the realistic prospects for the administration's legal theories in the cases that are still working their way through the federal courts. You do not want to miss that one, because the cases in the pipeline are going to be just as significant, and the overall pattern will only become clearer.